Headline news most affecting Chilliwack this week. Yes, we will have rain, but that might come with a few issues. Chilliwack made history with the municipal elections as the first openly transgendered candidate wins. Terry Westerby was elected as school trustee. Local Chilliwack teens getting together to create a politically aware video with a direct point to make on homophobia and the recent election campaign. And the Husker season comes to a sudden stop on the road. Josh will have more in sports. Our special guests this week include Paul Jaffe, who is legal counsel for Barry Neufeld. ChillTV in conversation with Paul Jaffe, who is somebody that you may know of, but you may not have seen. He is the legal attorney. He is legal counsel to Barry Neufeld, as we have just had the appointment with the Supreme Court of Canada. And a lot of people are still confused. Is this a defamation case? Is this something else? And we're trying to explain it as simple as we can. We are obviously going to get into legalese. Is this a true defamation by Mr. Glen Hansman towards your client, Barry Neufeld? Or is there something else in play?
Well, it started out that way. It was Barry Neufeld's response to a number of publications, many of which included statements by Glen Hansman, which Barry's claim alleges were defamatory and untrue. And so that's the bare bones of the defamation claim. And then what happened was, after it was commenced, the BC government enacted this called the Protection of Public Participation Act. And it was, the acronym for that is SLAP, Strategic Lawsuits Against Public Participation, is the mischief that the legislation is directed at. So the theory is that people who are wealthy and powerful and able to afford lawyers can exploit a power imbalance by using the courts to silence and punish critics on matters of controversy. So the act in BC was brought into force about 6 months or so after Barry started his claim, and then Mr. Hansman brought an application under that act to have Barry's claims thrown out because the underlying matter at issue is a matter of public interest. So that's all an applicant has to show to invoke the jurisdiction court statute. The onus becomes that of the plaintiff in a defamation case to show why the claim is credible. And then the court engages this balancing exercise, weighing the value of the plaintiff's day in court versus the public interest in permitting a defendant to express the views that are at issue. And so it's kind of very superficially a contest between defamation law and free speech. It's much deeper than that, of course, but that on the surface is what that weighing exercise involves. So it's a whole new area of law. Before the SLAP legislation, Barry would have had his day in court already on this claim, and it would have lived and died on the merits of the claim. But this new legislation has enabled people to delay at considerable cost sometimes, as this has become very protracted. And as you note, we've gone all the way to the Supreme Court of Canada on the issue of whether Barry even gets a day in court on his defamation claim. This is a brand new area, and the courts are very much still trying to figure out how it's all supposed to work.
Yeah, you brought up a very good point about the timeline with Barry's comments and then some of the changes. There is also some saying the argument, well, Barry was a school trustee at the time. Glen Hansman was the president of the BC Teachers Federation. Was it fair comment on his part? Or is that being hashed out in this, whenever the decision does come down with the Supreme Court of Canada?
Well, fair comment, two meanings. In the sort of lay sense, fair comment is, well, it's fair because Barry was taking one position, Glen was taking another, and they're in the public arena. You know, there's the cut and thrust of robust debate, and sometimes people get harmed in the process. That's all well known. But defamation law has always defined limits to what people are entitled to say about each other. and we say in the present case that that crossed the line. One of the issues raised by Glen's lawyers in Ottawa and at the Court of Appeal was that the value of his free speech ought not to be compromised. He ought not to be deterred from expressing those views, even if Barry is targeted with some pretty nasty comments. Our argument in response to that is that Glen's advocacy for the social justice objectives behind SOGI and so forth are not at issue. They haven't been questioned or challenged in any way. What has been challenged in the lawsuit are instances of what we say were libels. We're characterizing Barry's views as hate speech, for instance. That's a particularly egregious imputation. We say that's completely unfair. It doesn't fit the test of fair comment by any stretch. And so I think on the merits, both parties, I don't think there's any real dispute as to the merits of the claim. It's just the whole thing boils down to this weighing exercise. That's like a brand new area for the courts to look at. Like I say, historically, any meritorious libel claim would just basically go to trial, and these matters would be thrashed out at the trial.
The fellow trustee who was reelected, Heather Moss, has said that, and I'm just paraphrasing her, but should Barry lose this, the ripple effect could be significant. And it's not so much as we should all take our marbles and go home, but would that be that everybody else making comments, no matter what, would have to really watch their P's and Q's from this going forward, or is this going to have a domino effect? Is this going to have a ripple effect right across Canada?
Well, if Barry gets his day in court, it won't, because once again, the court will be invited to focus on the facts of this case and decide whether or not Barry has been libeled, and if so, what are the consequences? If Barry is denied a day in court, I think the message will be very loud and clear to the Glen Hansmans of the world, and by that I mean people in a position of power able to damage critics on matters of controversy, able to essentially use the media and their resources as ways to target people who speak in ways which are contrary to certain required narratives. Barry spoke out on a very contentious matter, and he was targeted by the BCTF, by CUPE, by the BCGEU, by the Attorney General of BC, by a number of activists and special interest groups. So I think I would say it's a slippery slope, but I think that even understates things a bit. If Barry is denied a day in court, it's essentially, it does two things. It's going to deter people from speaking out on matters of controversy, because nobody wants to be the next Barry Neufeld. And secondly, it's going to reward people for misconduct. It's going to be basically a dinner bell or a declaration of open season by those who want to shut down debate through the use of libel. So we did argue that point in Ottawa, and certainly when the Court of Appeal reversed the initial decision, which dismissed Barry's action, that was a real concern of theirs as well.
And now we wait for whatever happens next. Do we have any type of a timeline, or are we sitting and waiting for the next move from the Supreme Court?
The latter, and guessing when that might be is difficult. I've had one many years ago. It took 11 months to hear back, and sometimes they'll pronounce rather quickly, but 3 or 4 months would not be unexpected in the normal sense.
So we can.
So we'll see what they say.
Would it be a safe bet? Pardon the pun. Would it be a safe bet? January, February, into the new year.
I don't know how safe it is, but that would be a reasonable guess.
Okay. Paul Jaffe, again, who is legal counsel to Barry Neufeld. We will definitely be touching base again as this continues. And again, a big thank you for joining us, because I know you're a very busy man, and we shall talk soon.
You're very welcome, Don. Thank you.
Thank you, Paul. And you're watching Chill TV's News of the Week.